One of the things we want you to think about when you're representing a victim of domestic violence is to realize that they know the abuser better than you do, better than the court does, and better than anyone else does. We've had clients in the past who said that they did not want to ask for child support even though they were entitled to it, because they knew they were an abuser and they knew that was a hot button issue. And they knew that if they'd asked for child support, it would have put them or their children in a lot more danger. As the attorney, your obligation is to let them know what they could ask for, but you have to ultimately let them decide and realize that they may have very good reasons for deciding the way they do. I think it's perfectly appropriate to ask about it in depth to understand their reasoning, but at the end of the day, they know the abuser, you don't, so you should trust their opinion on that.
Never underestimate an abuser. Even if the allegations of abuse seem minor, you should never underestimate what that person could do if pushed into a corner, if they felt like they were being attacked by the filing of some sort of legal action.
And that's a great point. When it's filed and served on them is often a key point of danger because the abuser feels like they are losing control. And domestic violence often has a lot to do with control. So another thing we recommend is to ask your client what he or she thinks is going to happen when the opposing party is served. And also, if they are concerned about violence, to suggest that they have a safe place to go for a while, maybe a friend's house or a hotel or a domestic violence shelter or some safety planning to figure out what their plan's going to be, because that is a hot point in the litigation for danger.
And I like to schedule a check-in with my client. So like something that I actually put on the calendar where my client is going to contact me and say, okay, it's been 5 days since this person was served, I'm safe, things are fine, that person the abuser hasn't contacted my client. So I think that one reassures them and it reassures me as their attorney.
Absolutely. That's a great idea. Another thing I'll have some clients do is say, will you let me know before he's served? And while I can't tell exactly when it's going to be served, I can have somewhat of an estimate, and so I'll put a note on the file to call them before I send it out for service. I've also asked in the past that sheriff's offices let me know when it is served so that I can inform the victim. In South Carolina, the family courts have jurisdiction over the children unless another court has co-current jurisdiction. And so that's the case where we're talking about multiple states being involved, perhaps previous orders were in other states or parents live in different states. So I put the statute for the UCCJEA to help determine those disputes. But for the most part, if the child is in South Carolina, the family court in South Carolina will have jurisdiction. The venue should be in a custody case that's not a divorce case. So a custody or visitation case on their own. The venue should be where the defendant lives, if the defendant lives in South Carolina. Sometimes this is filed incorrectly. I know I've had defendants that lived in one town and I thought that town was located in one county and it turns out a corner of that town is actually in another county. So there certainly can be honest mistakes made this way. So the remedy is typically that the case will be transferred from that venue to the correct venue. However, the court does have the ability to waive objections to venue. The court can move forward if the objection to venue is waived.
And a child would need to reside in South Carolina for 6 months or more for South Carolina to become what's called the home state and to be able to exercise jurisdiction over that child. If we're talking about a standalone action or a child that has recently moved from another state where an existing court order might be in effect.
If it's a divorce case, it's a different rule. Mm-hmm. So in a divorce case, you have several options. It's the county where your client and the opposing party last lived together as husband and wife under the same roof, or the county where the opposing party lives, if the opposing party lives in South Carolina. If the opposing party does not live in South Carolina, then it can be the county where your client lived. So then we've listed for you the forms that you need to file when you're filing an initial case, whether it's divorce or custody case. The cover sheet, the summons, the complaint, the financial declaration, all of these are available, or at least forms of them are available on the SC Court's website. Also, a lot of local attorneys have their own forms that they've typed up that look similar. Whenever you file a case initially in family court, you're going to have a $150 filing fee. There is a way to get around that and ask for that to be waived if your client is under about 100% of poverty guidelines. You have to Google what that is, depending on how many people are in the house. But if they are under that point, you can ask that the filing costs and service costs be waived. So to do that, what you would do is you would file an in forma pauperis, which is also available at the SC Court's website, and the clerk of court will look at the financial declaration of your client as well as the situation in a whole and make a determination on whether those filing fees will be waived or whether your client will in fact have to pay that $150 filing fee. I've also added at the bottom there that if you're asking for a motion for temporary hearing, that is a paper in itself, and there's a motion information cover sheet. The cover sheets do change occasionally, so I think it's worth checking in with your local family court and figuring out what cover sheets they want and what order they prefer the forms to be in.
The motion filing fee is $25 as well. So if you were sending the summons and complaint along with the motion, then you would want to send $175 instead of just $150. And something I want to mention about if your client, if the filing fees are waived based on their income, some courts, and this absolutely varies depending on what court you're working in, but some courts will serve the defendant for free, so that will be included when the filing fee is waived. In other courts, that is not the case. So you would want to, if the filing fee is in fact waived, you would want to contact the court maybe beforehand and just confirm whether or not they're going to facilitate service or if that's something that your client is going to be responsible for. That can cost anywhere from it's generally $50 to $100 depending on what sort of process server you use. In some counties you can use the sheriff's office, but some counties don't do that for civil matters. So it really depends on your jurisdiction, and that's something you're going to want to look into before so that you can let your client know what their expected costs are going to be.
And we just wanted to say a couple words about privacy. The courts are trying to be more sensitive to this world we live in where information is very valuable and can be stolen. And so there's now a confidential redactor identifier form that you can file to protect the children's identities.
With regard to filing, there are some things that you should think about as well. Your client won't always be the filer, the plaintiff. And in some ways, I think it can be advantageous to actually be the defendant in some of these cases. So some things to think about. First, if you, again, have an unwed mother, if the child was born outside the marriage and the mother is the presumed custodian, then sometimes it might be safer for her to continue in that, to move forward without actually filing for court-ordered custody because she's already the de facto custodian, and you might keep her safer by, maintaining the balance, maintaining the status quo. And then I would say too, if you're a defendant, the other advantages are you might avoid the filing fee for your client. So if you have a client who doesn't have a lot of money and the filing fee would be burdensome for them, if they're the defendant, then they avoid that $150 and that $25. And then I think, if you're going to go to a final hearing or even at a temporary hearing, I think it's an advantage to go last. So if you're the plaintiff, obviously you're going to present your case first. If you're the defendant, you get to hear the plaintiff's case and then you get to respond to the plaintiff's case. So I think that that's an advantage. And, as long as if your client has a good case, being a defendant or a plaintiff doesn't really matter in the grand scheme of things. So think about where you want to be procedurally. I would also add in the complaint, what I see a lot of attorneys do is they really over-allege in the complaint. You really just need to allege enough to put the other party on notice. So your entire client's story, every single allegation doesn't necessarily need to be part of the complaint. You just need to make sure that you allege enough that the defendant is able to respond to those allegations.
And I would add to that if you are the respondent or the defendant, what you would file in response is an answer and counterclaim. And then after that's filed, so you have 30 days if it's served by process server or affidavit of service. If you are served by certified mail, restricted delivery, you have 35 days to respond. After you file your answer and counterclaim, then the plaintiff will go ahead and file a reply in response to your counterclaim if you had a counterclaim.
And as the attorney, if you're responding to a lawsuit, you would want to file a notice of appearance. It's called a Rule 8 notice of appearance.
The courts are also being more sensitive to the children and their privacy concerns to avoid identity theft. So we now redact the children's full names and their full birthdays to help prevent that. Since family court records are public records, so what we do is we have a confidential identifier form that you can use that's available also at the SC Court's website. So you can use that to have the children's full names and birthdays, and then how you're going to refer to them in your pleadings and in court. There are different ways of service. We briefly mentioned a couple of those. If the sheriff's office is available in your jurisdiction, that can be a very helpful one, especially if you need to keep your costs low for your client. Certified mail, restricted delivery, return receipt requested. You have to remember all three of those things. Certified mail, restricted delivery, return receipt requested. When you're doing the initial service, it does need to have that restricted delivery, which means that only only the defendant can sign for it. Unfortunately, sometimes the post office does not follow through with that and they let someone else sign for it, and that doesn't count as proper service. So if you sent it to the defendant's house and someone else at the house signed the certified mail, a restricted delivery, unfortunately you're going to either have to do it again or try a different method, because you do have to have service on the defendant. As Lindsay mentioned, you can find some private process servers. In the past, I've used some off-duty law enforcement officers.
If you use a private process server, be sure to check your affidavit of service when you get it back, because I've had more than one case where when you actually read the contents of the affidavit of service, it's defective. Like, it might have the wrong name, it might list the wrong documents that were actually served upon the person. So those aren't always fatal to the lawsuit, but they're things that you'd like to avoid if you can. And generally, in my experience, I've been able to send those back, and the process server has been able to correct those errors. So always make sure you check your affidavit before you go into court.
If you cannot find any way to serve the opposing party and you've tried multiple ways, you can file a motion for the court and ask for an order of publication, which would allow you to serve by publication in the newspaper. It varies by jurisdiction how many attempts that you have to make and what you have to do to make this happen, but I always do include an affidavit from my client about his or her knowledge of where the defendant is, as well as an affidavit from myself about all of the different ways that I've tried to serve this person. Also, sometimes we find ourselves in a situation where we can't get proper service, but we could let the defendant know about it in a way that doesn't count as proper legal service. And so this is something you may consider doing if that person might come to court where they could be served properly with notice. So for example, if the defendant, we don't know where he or she resides, but we do have their Facebook account. In the past, I've asked my client to send them a message on Facebook, letting them know about this, letting them know my contact information, and letting them know about the hearing date. Or I've emailed them a copy of the pleadings. Once again, that doesn't count as proper service, but if they end up showing up at court, it may overall be advantageous. So it's just a strategy to consider.
And this exceeds the scope of this training, but if you're trying to do international service of process on a parent, you should definitely consult an expert, because that's complicated and it can be expensive. So I would definitely defer to an expert on that issue.
That's a great point. For temporary hearings in family court, they work very different from how a final hearing works. At temporary hearings, the parties use affidavits instead of testimony. Unless you ask for special time, the temporary hearing will be scheduled for 15 minutes and you will be limited to 8 pages of affidavits. You do not want to exceed those. Now, you can attach things to your affidavit that do not count towards the page limit. For example, in my domestic violence cases, I'll often, in my affidavit, explain what the incident was or the latest incident or a more concerning incident, and I'll say pictures are attached. And so I attach those pictures to the affidavit, and those pictures do not count towards the limit. So one way you can get the most quality affidavits would be to make sure you do your clients, type up your clients and work on that with them, and then ask them to get affidavits from other people and take the 8 best pages, which would include your clients plus however many you can fit in to equal 8 that are the strongest affidavits. I always feel like there's better too much than not enough, plus those affidavits that will just remain in my file that exceeded the 8 pages, I could use later to help the guardian ad litem or for other purposes. They may be helpful.
With regard to the affidavits, a mistake that I made early on and often was I would go to temporary hearings with my affidavits and I would immediately hand those over to opposing counsel or a pro se defendant, and then we would work out an agreement before we went before the court. And so what I've done in those instances is essentially laid out my entire case through those affidavits for that opposing party. So don't make the same mistake that I made and go to court and wait until you know that you're not going to be able to work out an agreement, which I encourage you to try to do with opposing counsel or with a pro se party, but hold your affidavit sort of close to your chest until you absolutely need to hand those up and present those to the court. I also, when I organize, so I make a temporary hearing packet, and every attorney does this differently, but I actually prepare an index. So just my front page will just say this is what the docket number is. The next page will just be a really simple index, 1, 2, 3, 4. And then if I have a really long affidavit, I'll sometimes summarize them, because what I've found when you go in, you have 15 minutes, the judge will usually say, counsel, tell me what these affidavits say. And so you're charged with summarizing 8 pages of affidavits for the court. So sometimes you can do that in writing. Sometimes they'll look at it, sometimes they won't. It really depends on the judge, but that's something I like to do. And I've had many cases where judges have really appreciated that organized packet to be handed up to them.
Also at the temporary hearing, we're supposed to bring an updated financial declaration, a background information sheet, and temporary parenting plan. In my experience, not all judges require those things. However, I always prefer to be over-prepared than under-prepared, so I would recommend that everybody bring those things. The temporary parenting plan can help the judge by setting forward what you think the ideal parenting plan would entail, and it's easy to compare between the two parties. I do encourage my clients to be generous to the extent that the children can be safe when they make a parenting plan. So for example, if my client says he shouldn't see the kids at all, I really try to change their expectations there, give them a reality check, and then also try to delve into, are there real security concerns here? And if so, maybe we can find an alternative to work on those concerns. Or do you just feel like it's not fair and that's why you're not wanting him to see the child? Because I think if there are not real security concerns and safety concerns for the child, it doesn't look good for the judge that your client is wanting to withhold this child from their other parent. So I do try to make those as reasonable as possible. And also it will help when we try to reach an agreement to get in the right mindset. At the temporary hearing, a guardian ad litem will probably be appointed if the parties don't have an agreement. Also, the judge may set out a schedule for the guardian ad litem to do their investigation, to have a report, and for discovery to be completed, and for mediation.
And I would just say that with the financial declaration, just really quickly, They're not really intuitive, so actually make sure you read the directions for a financial declaration, because it looks at a picture of someone's income for a month. So if they hand you 2 pay stubs where they're paid every 15 days, it's going to require you to unfortunately do some math to help them fill out the financial declaration. I generally do that with my clients because I find that when they do them on their own, they're not accurate. And you're going to want to ensure that you attach the 2 most recent pay stubs to the financial declaration.